Hello, hello, hello. It's Attorney Mike Revan coming to you from Chicago. As usual, I have had a day. It's been pretty wild, but I've got all sorts of clips. I don't know. You know who's at fault for a good portion of this is Lookifacent's Lair. Alyssa's always to blame. She got me one. There's other stuff. There's stuff I just found. There's stuff I tripped across. It's a big rambling mess of awesome. Just straight awesome. We're going to kick it off with a SovCit that I wasn't up to speed on. Everyone's seen it. It's old. But this is Lookifacent's fault. She really pointed this to me, and I started watching it, and she is an absolute kook. This is the SovCit. I don't know her name, but I think she's the one who sued Team Skeptic. Shout out to Team Skeptic. I haven't talked to him in a while, but he's all good. He managed to get into some litigation with this broad. Oh man. Oh shit. And she is crazy. She's crazy. So I know you've all seen it, but we need to process it together. And there's just lots more where that came from. Let's get this party started, shall we?
PP in the matter of petitioner Charles Paul Nurswick versus respondent Lindsay Ann Deski. Ms. Deski, please state your name for the record.
Lindsay Deski.
Please raise your right hand. You solemnly swear or affirm any testimony you provide to the court today will be the truth and nothing but the truth.
I always tell the truth.
All right, very good. You may put your hands down. Ms. Deski, we had a bench warrant to issue for your arrest back in December 4th, 2003.
There was no for service on that. I was never given any service on that warrant, so it's invalid.
So the warrant issued because you failed to appear
For a court that I never received any service on.
for the show cause hearing. I do see that proof of service.
I was in another state, so there's no way I received any proof of service, and you guys had my email and my phone number, and nobody ever contacted me, so this needs to be thrown out immediately.
So that's not how the court.
Yes, the law says. The law says if I do not have proper service, it's an invalid warrant.
We're sorry, Karen. Karen, we are so sorry. We don't know how to make it up to you.
1 second. 1 second. Okay, Miss.
Me into trial on this matter because I've never been able to present any evidence.
Be quiet.
This is my hearing, and I'm allowed to speak at my own hearing.
I have to let you know I'm arraigning you.
You're arraigning me on an invalid warrant.
Oh, I did a stream with O'Donnell earlier. This judge is excellent. I saw a good portion of this. This judge is excellent. But oh, would I like O'Donnell dealing with this? Oh, did he just drop the hammer on a guy today who deserved it? He would not tolerate this crap. Not for 1 second.
This needs to be dropped immediately. Is this an Article 1 court or an Article 3 court? Because if this is not an Article 3 court, you have no right to adjudicate anything to do with my liberty interests. And my children are my liberty interests, and they are my offspring. And this man attacked me, so this entire PPO is based on fraud and is void. So that not only can you not arraign me, but you need to overturn the PPO immediately.
So, Ms. Deski, you were served on October 23rd, 2023. There was a show cause hearing for a violation of the PPO that occurred on December 4th, 2023. Just for the record, I have muted Ms. Deski because she refused to be quiet.
You're not allowed to mute me at my hearing. Is this an Article 3 court or an Article 1 court, ma'am? You have to.
Oh, no. Did she just unmute herself? Did she just unmute herself? She's got to go. You got to shut your hole, honey.
Answer me. Are you an Article 1 judge? Because if you are, President Trump said that you are not allowed to hear anything to do with my liberty interest in his executive order that he recently put out.
Do she know him personally or something?
All right.
Yeah, no, he didn't. Obviously, I took this from that channel. I can't. I put a link to the video in the description below, but I can't remember the name of the channel right now. I thought I had edited it out, but he might show up. He does make a good point. Like she has some connection to the president.
Are you arguing?
Is that you stopped Mr. Nurswick's mail? You were interfering with his mail, Ms. Nurswick, and wasn't able to receive his mail.
If you do not have a constitutional oath, then you have to recuse yourself immediately and let me have an Article 3 judge, because this has to do with my constitutional.
There we go. SovCit Encounters. Shout out to SovCit Encounters. I poached your video, but I tried to edit it, but there you go.
Rights. And Article 1 judges.
So the court is in receipt of a customer information form that
You do
appears
not consent to this PPO, and you must prove and show your oath.
USPS at an address of 18337 Ewell Road, Belleville, Michigan.
I was not living there. I had been evicted from there previously in June, so there was no proper service.
The petitioner filed a motion
She's really proud of that eviction, isn't she?
complaining that you, Ms. Deski, stopped his mail.
I didn't stop anybody's mail. He came and stole my mail and signed for a certified letter that he sent me, so I didn't receive it. And you guys won't let me show evidence. This has been going on for over a year, and I've never once been able to show evidence, and I've demanded a trial multiple times, and you've denied me a trial. So you're going to be going to prison under USC 18, 241 and 242, and I'm going to be asking for the death penalty for you.
Okay.
This is also a bill of payment penalties, which has been outlawed by the Constitution, Article 1, Section 9, Clause 3.
Nope.
You are using an unlawful PPO to withhold me from my offspring, which qualifies as kidnapping.
There shouldn't be any withholding from the offspring. Oh yeah, I think that's in the Constitution somewhere.
And hostage taking, and treason, and torture.
Is it capital felony treason? I need to know. I need to know if it's capital felony treason. Please, Karen, please tell me now.
Tylenol for my tooth. Sure. Thank you.
Thank you, Mary. You're right. You're right. I shouldn't be saying anything. I shouldn't be saying anything. We should believe all women. You are correct. You are correct. I'm sorry. I'm sorry. I beg forgiveness.
This matter is void ab initio from the beginning because it's based on fraud, and fraud vitiates everything. Marbury versus Madison, anything repugnant to the Constitution is void.
She just voided herself.
This is a violation of my free speech. This is a violation of my right to petition the government for redress of grievances. It's a violation of my Second Amendment because you said I couldn't have a weapon or bear arms.
Mr. Nelson, I'm gonna put you in the breakout room with Ms.
This is a violation of my Fifth Amendment. This is a violation of my Sixth Amendment. This is a violation of my Seventh Amendment. This is a violation of my Eighth Amendment right, my inalienable Eighth Amendment right. This is a violation of my Ninth and 10th Amendment rights. You are violating all of my rights. and I have not ever been allowed to be heard.
Why don't you just say a violation of 1 through 10, all objections, and carry on with your day?
Any objection?
All objections.
Due process allows me the right to be heard, and this has been ongoing since 2023, and I have never had the right to be heard.
Oh my God, we hear you.
Okay, we don't have a prosecutor. I'm putting this over. Can we, I want to reconvene at 2 o'clock.
I'm demanding a quo warranto.
All right,
And I need to
Deputy,
see
did you
all-
hear me? Officer?
Your Honor, I do have a 2 o'clock. Did you want me to come back? I have a 2 o'clock in
I don't need an attorney. I don't consent to an
Yeah, I
attorney.
can't. I don't have a prosecutor. I need you to come back. What about
Prosecutors.
2:30?
I want to say something. You guys are, I've
Miss
talked about
Williams,
Your Honor, I'm talking to
5
you.
days.
I
I've been
have
here for
no
5 days.
prosecutor.
I was
I got
not even
you.
notified of this court. I was not even given notice of this court date, and I've
Yeah,
been here.
so-
5 days.
Mr. Nash,
Let's
please
say
be quiet.
1:45. I don't have a
You
prosecutor.
need to
I
be
can't do
quiet. This is
anything.
my hearing.
Can we do 1:45, officer?
Yeah, 145.
Okay,
All right,
I'll
we'll
be
see y'all
back at
back at
1:45. Okay, thank you, Your Honor.
I do have one question.
Go ahead, officer.
Just for staffing purposes, can you give a time, because that's right around shift change, do you think that that hearing would be done by 2:30 or are we
I'm waiting
looking
on
at
a prosecutor.
2:30?
I can't,
Well, it has
the
to,
record is
Your Honor, I
going now.
have a 2
I
o'clock.
can't call
I
it.
don't
So,
need a prosecutor. I'm asking for this to be
Okay.
dropped.
yeah, 1:45 is the time that I have.
Why
Okay.
won't you answer any of my questions?
Your Honor, I'll see you at 1:45. Thank
Sounds
you.
good.
You just ignore my questions.
No, I know why they won't answer her questions because she won't be quiet. But I'm telling you, compare her to Eric Martin has nothing on her. So let's go into the next phase of the hearing and see what's going to happen there. Okay, let's go.
4850-PP in the matter of Charles Nurswick versus Lindsay and Deski. Mr. Tudge, if I could get your appearance for the prosecutor's office?
Good afternoon, Your Honor. Gregory Tudge, B85961 for the people.
All right, Ms. Fort Williams, your appearance, please.
Good afternoon, Your Honor. Gail Fort Williams, P35963, counsel on behalf of
All right, Ms. Fort Williams, you had an opportunity to speak with Ms. Deski in the breakout room.
Why is there still an attorney on my case when I said I don't want one?
I attempted to speak with her, Your Honor.
I do not want or need an attorney.
All right, Ms. Fort Williams, I just want you to stand by at this time, if you can do that.
And I'm entitled to relief from judgment under Michigan Court Rule 2.612 because I was not personally notified of this matter. And so it needs to be dismissed immediately.
Ms. Deski, you were arrested for a warrant issue because of your failure to appear.
A failure to appear on something I was not personally notified on. So under Court Rule 2.612, personally notified, I am entitled to relief from this proceeding and action.
Okay, let me hear from Mr. Tudge. Go ahead, Mr. Tudge.
Your Honor, it does appear that the 2.512, I believe, was the citation, which 2.516.
No, I'm sorry, 2.612.
Oh my God. This is all you need.
Chapter 2 of
which is number 1, wrong.
Just spit it out.
the Michigan Court Rules governs the civil procedures. This being a quasi-criminal matter,
This is a civil procedure because it's family court.
Hold on, Ms. Deski, let Mr. Tudge speak.
It's not quasi-criminal, this is civil.
All right,
So that's a twist.
I really want to take that clip to court with me. I don't know if it would go over well with the judges, but I just want a little monitor and a button, and I can just press that whenever I feel like it. It may result in contempt for me.
This is a family court matter.
Ms. Dineski, please let Mr. Tudge speak first, please. Go ahead, Mr. Tudge.
I thought this was my hearing. I should be the one speaking.
Mr. Tudge is from the prosecutor's office.
He doesn't need to be on this case because it's civil. Prosecution doesn't happen on civil cases.
All right, go ahead, Mr. Tudge.
Thank you, Your Honor. The MCR 2.612 does appear to be governing civil proceedings. This matter being a quasi-criminal proceeding does and is controlled by the court rules which address misdemeanor offenses unless otherwise stated in Chapter 3 under special proceeding. I do believe that the cited rule is inapplicable for this proceeding.
You may proceed.
I'm sorry, I didn't hear him. Did he say applicable or inapplicable?
It is applicable, Ms.
Oh, okay.
Okay, go ahead.
Your Honor, I must correct the court. The argument is not applicable, inapplicable.
Oh, he said not applicable.
Why would it be inapplicable?
Your court rule. He's saying the court rule your side, his position, and I agree with him. Let me just say that for the record, that the court rule your side governs civil procedure. It doesn't govern under quasi criminal matters.
I get it. I get why everybody said everything they said, but it's just a mess for no reason. Just because she's so nuts, it just emanates out. Everyone starts losing their mind.
This is not a criminal matter. This is a civil matter. It's a domestic matter. How is that criminal?
Ms. Dineski.
And in criminal procedure, it's the same thing. These also, the criminal code also. The reason why I looked up the.
I'll give you an opportunity to speak, but I need to hear from Mr. Tudge first.
But it's my hearing. I should be heard first.
No.
This is my hearing. I'm the one who's supposed to be heard, not the prosecutor.
But they're being heard because you're violated a PPO.
I didn't violate anything. I was not notified.
Sorry, the allegation that you violated a PPO.
Okay, well then I have a right to say I was not notified.
I'm going to give you that opportunity, but you have to. The allegation is that you violated a PPO. You have to let the prosecutor's office, the representative of the attorney from the prosecutor's office, speak.
She definitely has a lot of energy, and I know the judge want to hurry up and get through this hearing. She just doesn't stop.
Go ahead, Mr. Tudge.
Your Honor, I don't believe I have anything further as to the argument. As it relates, I would ask that the arraignment for the bench warrant continue, and I would also ask that the court inform the respondent of the standards for which respondent will be held if proceeding pro se, and I believe it would be appropriate.
I'm proceeding sui juris and persona.
Well, I am going to ask Ms. Fort Williams to operate.
No, I don't want an attorney. I do not want an attorney.
Ms. Dineski, I have acknowledged the fact that you are not wanting an attorney.
No, I refuse it. It's not that I don't want one.
I have Ms. Fort Williams to stand by. She's just going to stand by.
Even though I
what else would
appreciate
you like to say, Mr. Tudge?
I believe it may be of benefit for the court to voir dire or Attorney Williams to voir dire respondent as to a right to have counsel and whether respondent knowingly, intelligently, and voluntarily waives the right to counsel.
All right, Ms. Dineski, you understand? Go ahead, Ms. Fort Williams.
Your Honor, I just wanted to say, Ms. Dineski was speaking about being served with the violation, and she's indicating that she was not served. She may have been quoting the incorrect court rule. I don't know. I don't have the court rules in front of me. It doesn't matter, though. Either way, of course, anybody in court has to be served with the appropriate papers. What she is indicating is that she was not served. And I indicated to her, but I don't think she was listening to me because she was talking and I couldn't talk. I indicated to her that this is an arraignment and that she will have the opportunity to address service or lack thereof, if that is the case, when a trial is set or whatever is set.
No, according to versus McVicker, I can challenge us at any time.
Your Honor, Ms. Dineski, you have to be quiet. For purposes of what she was indicating, Your Honor, it is true that everyone has to be served I don't know about that court rule, and it doesn't matter whether she's quoting all these rules. It doesn't matter. She's indicating she wasn't served. That's all. Thank you.
Thank you. But the thing is that it doesn't matter if this is
Hold
an
on,
arrangement or not.
Miss. Procedurally, there are things we have to do, Mr.
No,
Nesky.
not if my rights are violated. Procedure does not have my rights.
Mr. Tudge, do you have a response to that?
Your Honor, it's indicated, I believe in the court record, a proof of service has been submitted. If there are further questions as it relates to service, and ultimately it may be, however, I leave this to either respondent, or if respondent wishes for an attorney, respondent's attorney to address that if there is a request or a motion to have the court issue a summary judgment as to the alleged violation, the burden of proof would be on the respondent to do so.
All right.
It would not be. The burden of proof is on the.
Okay, that guy makes a lot of sense in substance, but his delivery sucks. He's a smart guy. He's doing the right things. But you got a whack job. You got to be more forceful. You got to spit this out. And you got to be angry. Even if you're not, you have to pretend to be angry. That's the energy required in this moment.
The one who would process the service. I was out of state when this hearing was set up.
I do show that a proof of service was filed for notice of hearing for the show cause that took place on December 4th, 2024 by the attorney that was representing Mr. Nurswick.
So where did he serve it to? Because I wasn't even in the state of Michigan. I was living out of state at the time, and you guys they have my email, and they never even emailed me. They have my phone number, so I wasn't notified by phone, email, or mail. So if they served it to the Elwha house, Chuck is the one who signed it, which is fraud. He has been defrauding the court since the beginning of this.
There is a proof of service in the file that was filed on November 8th, 2023, that a notice of hearing for the show cause on December 4th went out.
They probably sent it to the last known address for, that you left with the court. And if you haven't updated it, you're screwed.
Have you, Ms.
I don't know. I haven't
Fort Williams, talked to
seen
your
this
client? How would
specific
you
part.
like to enter a plea on her behalf? What plea?
No, she doesn't need to enter a plea on my behalf. I said I don't want an attorney. Why do you keep going to her? I want to speak for myself.
All right, let me say this, Ms. Dineski,
Because you're dumber than a box of rocks, and they're trying to protect you.
you've been advised of your right to have counsel, is that correct?
No, I have a right to assistance of counsel.
All right,
Okay.
do you want assistance of counsel, Ms.
She can
Dineski?
assist. She already told me her opinion, so I appreciate that, and I'm competent to speak for myself now. But I do appreciate her very much.
So you asked for the assistance attorney, Ms. Fort Williams.
No, I didn't ask for it. She gave it to me, and I accepted her opinion. But I don't. The law does not agree that I can't ask for this to be dismissed in an arraignment, because Lufkin v. McVicker
So
says
your
that.
request for dismissal is denied.
Why?
And Your Honor, I would ask.
And you have to. I'm also.
Hold on, I need to hear from Ms. Fort Williams.
It's my turn to speak. When do I get to speak?
Hold on.
Your Honor,
Ms.
I asked
Fort
that a
Williams.
plea of not guilty be entered, and I'm asking that she be given personal bond. She is a resident of Detroit, Your Honor, and she's been incarcerated since the 13th. And I'm asking that she be released on her personal recognizance. Thank you.
Thank you. Because I'm living locally. If I knew there was a court hearing, I would have been there.
Mr. Judge, if I can hear from you, please, as it relates to bond.
Your Honor, as it relates to bond, I did have the opportunity to speak with the petitioner prior to today's hearing. It's my understanding that there has been numerous instances of contact with the contact from respondents beginning on or around December of 2022, which I understand predates the personal protection order, this being when unwanted contact is alleged to have began, and the last instance of unwanted contact on or around February of 2025, just 5 weeks ago is what I've been informed of. I would, given both the allegations of contact and the information of continuous contact, as well as respondent's failure to appear for the prior proceeding, I believe was set for a bench trial, it does appear that there may be a concern of respondent attending future court hearings. And as such, I would argue that a GPS tether would be appropriate for both the security of the public and petitioner, as well as securing the respondent's future attendance at court proceeding.
All right.
Do I get a chance to speak on my own behalf?
I'm going to give you that chance. Ms. Deski, are you incarcerated for any other matter?
Yeah, I'm incarcerated, falsely arrested, because I asked to talk to a supervisor when I was pulled over in River Rouge, and they beat me up and pulled me out of my U-Haul and beat me up and arrested me and put me in a dungeon for 3 days and then brought me here.
All right, do you
So
have
I'm fighting those charges as well. And the thing is, this PPO, since the beginning, ma'am, I have been telling you that this needs to be dismissed. I have not had my chance to put any evidence in. You unlawfully dismissed the PPO that I had against Charles Nurswick, and then you went ahead and reissued a PPO right after you dismissed the one that I had against him, which was unlawful. You dismissed the original PPO against Charles Nurswick that I had after he admitted to trying to run me over. I'm talking now. It's my turn to talk. Let me talk.
What is your bond on the felony case? You're charged with a felony right now?
I am, unlawfully.
And
I'm already getting a tether, so it's a moot point.
So what is your bond on that case?
$10,000.
That
And I'm going to be asking for a bond reduction.
All right, so
I'm not even going to be getting out
And it's going to be denied.
anytime soon anyways. But my point is that this needs to be dropped.
All right, the only thing she said so far, she is absolutely insufferable. She doesn't know the law. Her personality sucks on every front. But she said the first thing that gave me one modicum of respect for her, she realizes she's not getting out anytime soon.
Because I've never been able to show evidence, and on my
at a $10,000 cash surety with tether.
Yeah, with a 1 person or 10, whatever. I have to pay $1,000 to get out.
Okay, so it's 10,000, 10%.
I guess, yeah.
With tether.
She doesn't like chili? Well, that's good. That's good she's on the right side of that, but she's already...
With a tether. So the thing is, but my point is, I would like to speak on my own behalf about this PPO, because you dismissed, you need to recuse yourself because you have violated my rights from the beginning of this case. You did not let me show evidence in my original PPO case, and you dismissed the PPO when I never had a chance to have evidence. And that man, Chuck, who kidnapped my babies from me, who has never even been found to be the biological father of these children, lawfully. The thing is that you dismissed. You said I could have a chance to talk. Please let me state my case.
Mr. Tudge would like to speak at this time. Go ahead.
It's my turn. You said I could have it, and you keep letting them speak, and you will not let me speak.
Mr. Tudge,
It's my turn to speak. So I'm going to say that this needs to be dismissed because you did not let me show evidence, and then you dismissed the PPO against a dangerous man who admitted to trying to run me over with his vehicle on his documents, and then you dismissed it and turned around and gave him a PPO against me when I was asking him to let me see Haley, who I raised for 5 years, and to get diapers for our babies, who he had abandoned for over a month, and then he kidnapped, and then you facilitated that kidnapping. So you must recuse yourself from this case because you have violated my rights numerous times, and I've asked for a quo warranto. I have asked you to show me your Article 3 oath, and you have refused. And if you're an Article 1 judge, you cannot oversee this matter.
Mr. Deski, your request to dismiss the matter is denied.
Why?
Mr. Tudge.
Why? What lawful?
I got your oath right there. Your request is denied because it sucks and there's no basis for it in law. Sit in jail. You happy now?
Reason do you have to continue this?
Mr. Tudge, what would you like?
What law, Judge, you need to answer me. What lawful reason do you have to continue this?
1 second. Go ahead, Mr. Tudge.
Thank you, Your Honor. As it relates to As it relates to other bonds, I did have the opportunity to search. I believe the case in reference would be a 22nd District Court case. Presently, my records are not showing any arraignment having taken place. I did search the Michigan court case search system and did not locate any present bond or active case involving respondents. Now, I do see that there had been issued charges for assaulting, resisting, or obstructing a police officer, which would be placed at the 22nd District Court. Also,
those were dropped. They told me that they were dropped and they let me go because they wrongfully arrested me based on a false allegation. So that I have to deal with.
Trying to get information from Mr. Tudge. Let him
No,
finish.
I know, but I'm letting you know what happened in that situation. Somebody had me arrested, and then they found out that the guy gave them false information, and they originally were going to charge me with that, and then they let me go that night, and they said they were dropping the charges. So for some reason, it just never got taken out of the lien system, and I didn't know that. So I do have to deal with it, but that's not my fault. That's the 22nd District's fault.
Okay, let me hear from Mr. Tudge. He's reading from the system so that I know what it is that he sees that's in the system. And so you know what's in the system. Go ahead.
I do appreciate that. Thank you.
I would also note a case out of Washtenaw County that does appear to have also been charged with 2 offenses, misdemeanor disturbing the peace and attempt misdemeanor of assaulting, resisting, or obstructing a police officer.
That's the one that got dropped.
I'm not in possession of any adjudication on the matter.
That's the one that got dropped. I'm sorry. I thought that was the 22nd Circuit.
So I can't provide any further information. As it relates to respondents, what I would interpret as respondent's motion that Your Honor recuse yourself from this matter. I don't believe the requirements for recusal are met. There being no argued of impropriety.
Well, it's not really up to you to decide. You weren't there on the original case when she violated my rights and denied me a trial in the original PPO and did not let me put my evidence in. So because you violated my rights in that original PPO, you must recuse yourself. And I am demanding a new judge. I'm demanding a higher judge. I'm demanding the chief judge.
All right, Mr.
I have a right to that.
Mr. Tudge.
Like maybe outside of this, you'd be a cool lady, but you violated my rights in this court, and so I have a right to a judge who has not violated my rights.
Are you asking that Ms. Deski just be placed on tether?
Yes, Your
Honor. Yeah. I don't care if you want another judge. I don't care if you think I'm a cool lady in another context. Pound sand.
Honor.
And I object to that. I should not have to be on a tether. I've not broken any laws. I've not harmed anybody. I'm the only one who has been harmed by this. This unlawful PPO has kept me from seeing my biological offspring for 2 years. This unlawful PPO has kept me from my babies for 2 years. They took a good mother. I was nursing my babies. I was with my babies every single
I'm guessing that's the best thing for them.
day. And you guys helped a man who tried to kill me to cover up his crimes, kidnap those babies. You should be ashamed of yourself. And so because you helped kidnap my babies, I deserve a different judge. I am entitled to a different.
Well, that's it. A woman said it. It must be true. The judge needs to be arrested immediately.
Different judge. You have shown misbehavior and impropriety under the canon laws of the judge's rules.
Mr. Deski, I'm going to enter a not guilty plea on your behalf. You'll be given.
I don't consent to plea. There should not be a plea. This should be dropped.
I'm going to give you a $10,000 personal bond. You can be released on GPS tether.
Well, then I'll just add that to the criminal charges that I'll be filing against you in federal court.
Okay.
With the executive order that says that are you or are you not an administrative law judge? Yes or no? Law judge or are you a judicial judge?
I'll do the 10% on the 10,000.
Are you an administrative? Why will you not answer my questions? I have a right to ask you a question.
Because they're stupid and you're speaking out of turn, and she wants to get through her call because she's got other things to do.
As a public servant.
She can.
Are you an administrative law judge, Regina Triplett? Are you a judicial?
You're lucky you're not in contempt. You really should be. They just don't want to do the paperwork because you're already incarcerated.
Judicial officer.
1,000 has been paid and she receives a tether, then.
Your Honor, I apologize for the interruption. However, when respondent was speaking, I noticed that it appeared that you were speaking. The audio did not come through.
Let me ask you this. So what day would you be able to do a trial, Mr. Tudge, on the allegations?
Your Honor, I did, when speaking with the petitioner, it's my understanding that there may be evidence that has yet to be sent to my office. I believe a period of 3 weeks may be sufficient to receive the evidence.
Why is he allowed to? Why is a petitioner?
I'll make that a 10,000 personal, but she has to have a GPS tether on.
So why is the petitioner allowed to submit evidence, but I've not been allowed to?
Deski, I'm going to release you on a 10,000 personal bond, but
What does that mean? I don't have money to pay anything.
You don't have to pay any money. You just have to show up for court for your next court date. But you will be placed on GPS tether because you.
Big dummy. That means you don't have to pay anything. You know how you just keep going on and on like you know something about law? Pretty much 90% of the people who watch my channel picked up on what a personal bond means as she stated it. So you know less than people who casually watch this to unwind with a beer. Let that sink in, dummy.
Cannot violate.
But I wasn't personally notified up until the point when if you guys know, remember all the hearings I did show up to? Because I was notified. When I'm notified, I show up. You cannot put a tether on me when I was not personally notified.
Your Honor, we just need a date.
Can you tell me, can I ask a question? What address was that proof of service sent to? Like, where did they send that?
They're going to release you. Okay, you're going to get a 10,000 personal bond.
It's not about that.
I know, but
I would like to know what address did they send that information to?
You'll be able to look at the file. You'll be able to go into the system and see what address they have for you and access.
But can you just tell me, isn't that on record where it was sent to?
Mr. Deski, you'll be able to check that yourself.
Right.
But I want to know right now, because if they didn't send it to the address that I was living at, this needs to be dismissed.
Deski, go to the records division in the basement of the city county building and you can pull all the records for the entire case. What address they served, the proof of service.
But I'm telling you, you told me it was the Elwell address. I was evicted from there in June.
No, I didn't give you an address. That's why you should go to the records division in the city county building in the basement.
But it should be, you should have the information in front of you.
The judge has indicated that you can check that yourself. You got to
I
listen.
know, you can also give it to me right now. Why are you refusing to give it to me when you guys have it?
You have to be quiet and listen.
When you get out, you can go to the city county building in the basement, but you must have tether.
But I can't get out because I have this other thing that I have to get bailed out for and I have no money.
Your Honor,
Deal with that other case, however you deal with it. I've given you
Okay, but I'm here and I can't get out. That's why I'm asking you what address, because I'm not going to be able to get there.
Your Honor, may I just say this? We're going around in circles. May I just request that we just need a date? That's all. Because
Can I just get the discovery sent here?
Williams, I was just given a date 1 second ago. I was waiting. So May 27th at 9 a.m. will be your next court date. You have that, Mr. Tudge, Ms. Fort Williams?
Yes, Your Honor.
All right. So we'll see the parties back on May 17, 2020.
No, you said 27, right?
27. I apologize.
Okay, thank you.
At 9 a.m. Okay.
Your Honor, is
So
this
why is it okay for my rights to be violated? I want to know. Why is it okay for you to violate my rights?
Mr. Deski,
I want you to prove jurisdiction. Prove that you have jurisdiction over me. I'm doing a quo warranto. I'm demanding a quo warranto, and you have to prove jurisdiction over me.
Gonna get out with tether. You'll be able to access.
It's not about that. This whole entire matter is void ab initio. So you have never proved jurisdiction over me from the beginning.
Say something. Go ahead, Mr. Tudge. You got to get it out.
Your Honor, is the matter scheduled for a trial or a final pretrial?
Let's schedule it for a final pretrial.
So that's May 27th at 9 a.m., Ms. Deneski.
Yes,
Thank
and
you so much, Your Honor.
that you can get whatever discovery or whatever you need. Contact Ms. Abrams, and at least we'll know on that you have everything.
So the thing is, though, is that I need you to, I'm doing a jurisdictional challenge right now, and you have to prove jurisdiction before this can move forward under Michigan and federal laws.
Your Honor, she has the date. So we have, is this concluded?
Yep.
Ms. Deneski has the date.
I'll take care and be safe. Thank you.
Thank you.
Oh, so you're not gonna establish jurisdiction. Okay, one more crime.
You want to take a minute to stop driving before we start?
Yes, sir.
This one here is Alyssa's fault. The Hot Mess Express continues. We've got us a garden variety Karen, who of course has done nothing wrong. Just ask her. Just ask her. Being wrongfully accused of a traffic violation.
Well, I can start before you'd have to testify. All right. This is a citation. It was issued on February 24th of this year on 109th Avenue there in Lee Township. It's a speeding citation on an actual 74 and a 55. Yeah. However, it was only written as a 1 to 5 over. So, ma'am, you're here on this 1 to 5 over speeding ticket to do one of three things. First is you could admit responsibility to the citation, or 2, admit responsibility, but you'd like to provide some sort of explanation as to how or why this happened, or 3, you wish to contest this citation. In other words, fight the ticket at what we call informal hearing. What were you looking to do?
Contest it.
All right. Then we'll wait for the officer to get somewhere where he can park for a while, and then we'll get to that. All right, so first things first, I'm going to swear you both in. You want to go ahead and raise your right hands. You swear or affirm any testimony you give here today would be the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
Ms. Arzamana Steph, it makes a lot more sense to me to start with the deputy. He has the burden to establish to me why you were issued a citation in the first place. But after that, you'll have an opportunity to either ask questions or testify on your own behalf. And so with that, Deputy, you want to pick up the narrative somewhere where it makes sense and explain the issuing of this citation.
Yes, sir. Can you give me a minute?
Yep.
10-7 for a Zoom meeting. Okay. So as I was traveling on 109th, my radar was activated, tested before shift and after shift. I observed Ms. Arzametz. Yes. I observed Carrie's vehicle traveling eastbound on 109th. The radar detected speed was locked in at 74 miles an hour in the posted 55 mile per hour zone. That is when I located a safe spot to turn around. It began following the vehicle. The vehicle turned right on 60th Street, and she had pulled into a driveway, in which at that point I then followed behind her and conducted my traffic stop. I advised her that the radar speed was detected at 74, in which she did say she was not aware how fast she was going.
All right, and ma'am, what is it you wish to tell me?
I have absolutely no idea how fast it was going. I want to just be honest about that. I don't. I just got that car. It is 21 years old. It's incredibly loud. I was heading to a stop sign. I don't remember that he was traveling at all. He had his lights on, and I can't even remember if someone was pulled over after they had already left. I can't remember. But I saw him a good mile ahead, and I was on the phone. I have a work phone and a regular phone. My work phone was on the seat, and I said to my friend, "Oh, there's a cop up there. I gotta stop." I stopped, she hung up, whatever. I could see him. He wasn't hiding. He was like a mile ahead with his lights on. But I can't remember, like I said, if anybody was stopped or if he had finished the stop. I don't know. He absolutely shocked me because I was heading to a stop sign.
Thank you, Andrea. There we go. That'll just save us some time right there. Nailed it.
I don't even think I was 0.3 of a mile away. He was parked on the side of the road. And I don't even think I was 0.3 of a mile away from the stop sign. And the only reason I'm challenging this is I can't even imagine I'd be going 74. Maybe I was, but I can't even imagine I'd be going 74 when I've got really crappy brakes. It's a brand new car. I mean, not brand new. It's a very old car, but I just gotten it. And I was heading to a stop sign, and I was going to take a right. And the house that I was going to, I looked on Google Maps, was 0.2 of a mile from that stop sign on 60th. And I didn't even know he was behind me. It was an incredibly huge.
Ma'am, you had me at maybe I was. The officer says you definitely were, and you're saying perhaps I was. That there is a guilty.
Long driveway, very, very long. And it was a loop, and I'm an Amazon driver. And so it was a loop. That's why I was in the driveway. I'm trying to explain. It was a loop driveway, and the loop went behind the house. And when I got to the front of the loop, I was so shocked. I had no idea he was even coming. I even said to him, "Where did you come from?" Because I'm like, that can't be the cop that was on the side of the road. I was so stunned. I mean, stunned. And then he said, "Did you know how fast you were going?" And I really didn't know, and I still don't know. But I'm just shocked that I was even speeding, heading towards the stop sign. But I don't know. But I just had to try and fight it. Because
I think the problem here is you probably got radared in a different place than you're thinking you got radared. But we'll go back to the deputy. Deputy, I have you saying that, she's traveling eastbound on 109th. Where were you and what were you doing when your radar hit her?
So I was traveling westbound on 109th.
So, ma'am, he's not a stopped car. He's traveling. He's going the opposite direction as you.
No, he was on the side of the road. It had to be that one. There was no other cars. There was nothing else there. There was a cop on the side of the road about 0.2 of a mile before 60th. That's the only car I even saw. That's why I'm like, where was he?
I mean, I'm assuming that's him already stopped waiting for you to pass him up so you turn or spin around on you and pull you over. But we'll hear from the deputy. Go ahead. So, deputy, you are moving, traveling westbound. She's traveling eastbound. When did you turn your lights on?
So I actually I found a driveway to quickly turn around. I was able to catch up to the vehicle on the intersection of 109th and 60th. On 109th and 60th, there is no stop sign. The only stop sign is going north and south, not east and west. So I seen her turn right onto south on 100. Turn south on 60th Street, and then that's when she went down towards that house and actually pulled in the driveway.
Yeah. So, ma'am, I think you're talking about two different locations.
No, I'm not. I saw him will you just hear me out a minute? He was
But, ma'am, there is no stop sign on 109th at 60th. 109th just... Okay.
I didn't know. Okay, I don't know where the stop sign, if there was one. I don't know.
But, ma'am, that's what you testified to, is there's no way you could be going that fast because you were 0.2 of a mile from a stop sign.
Okay, well, I'm 0.2 of a mile from turning. I had to turn there. I'm not going to turn at 74 miles an hour. And
But, ma'am, there is no stop sign. So, in other words, you're already confused about where you're talking about.
No, I'm not
And
confused
he was
about
not
him.
stationary. He was moving. So
I'm
your
not- no, he
recollection of
wasn't.
events does not match the
No, he
officer's
was not.
recollection of events.
Sir, I saw him a good mile ahead. He was pulled over. He was not
Ma'am.
moving. He wasn't coming
Ma'am.
towards me.
Ma'am, hold on a second. You said he was stopped with his lights on, right?
Yeah. Yeah.
Okay. Police officers only turn their lights on when they're either trying to pull someone over or they pulled someone over. So,
Right.
Deputy, were you already at a stop with somebody else when you saw her vehicle?
No, I was not.
So the only time you would have turned your lights on is when you were in pursuing her and already decided to pull her over for a speeder.
Yes, sir.
All right. So, ma'am, I don't know what you're talking about, but it seems to be a very different scenario than the deputy. So all I can do is go by what I can corroborate myself. And what I know is there is no stop sign for 109th at 60th. The stop sign is for 60th, not for
But why would I
109th.
go? But why would I go 74 miles an hour on a turn?
But ma'am, I'm not sure your recollection of this event is correct, because what you said is he's stationary with his lights on,
It was.
and then he showed up at the house you were at.
Why would I go 74 miles an hour? Because you were driving too fast. Like, this is the dumbest thing I've ever heard.
So,
He
for
was
purposes
stationary.
of, and you don't know how fast you're going anyway. How fast do you think you were going down 109th?
You know, I'm not from around there. I was doing an Amazon route, and I'm not from over there, and I know it's usually 55, 60 right in the country. And no, there was nobody else. He was
So, ma'am,
stationary.
I have testimony from him of how fast you were traveling. Would you like to tell me how fast you were traveling?
I can't tell you how fast I was traveling. I can't because I don't know.
Then if I have to pick which version of events here makes more sense to me, makes a lot more sense the deputy's version of events. I would find you responsible on this informal at 1 to 5 over. If you wish to appeal this further to formal hearing, you must ask for that within 7 days of today's date, and you must come in and pay a cash bond in the same amount as the fine to guarantee your appearance at formal hearing. Do you understand your rights on appeal?
I do. It doesn't make any sense. He was pulled over. I'm telling the truth. He was already pulled over way a mile ahead of time, and I wouldn't go 74 miles an hour on a turn. I would never do that. I was going to turn. I knew I had to turn.
Ma'am, by the time you turned on 60th, he had already did a 3-point turn and began following you. You got radar
Next to me.
well before 60th.
He was on the same side of the road as me. He wasn't on the opposite side. He was on the same side of the road. Did anybody ever look at the camera?
Ma'am, the only way they have their camera on is if their lights are on. And his lights weren't on until he tried to pull you over.
They were on. When I came up the road, they were on already.
Deputy, I'll give
They
you
were
one
on.
last chance. Is anything she's saying making sense to you as or your recollection of events?
No, sir.
All right. We're done here. Thank you.
We're done. You
I
lose.
think
You're worth
you have
0
the
points.
next one as well. Looks. Oh, no, I don't think this is your person. I think it's the next person. So I'm going to pop you back over in the waiting room.
I don't even know what I have next.
All right, Mr. DeWitt, I'm assuming that's you. You are in the right place just a bit early. I don't have any other parties here for you. I'm going to pop you back over in the waiting room. We'll see if you're
Court calls.
Okay, this is kind of fun. I caught this by accident. It's short. It doesn't matter. We have an ongoing thing. Shaquille O'Neal shows up in Judge Simpson's courtrooms every so often. Today, I should I should clickbait my thumbnail again and say Shaquille O'Neal fails to show up to court. This is like 20 seconds.
Case the people versus Shaquille O'Neal Tubbs.
Oh, what a total failure this is. Good morning. Maria Burton Harris, Chief Assistant Prosecutor, appearing on behalf of the people.
Proceed. Dunaway?
Assistant Public Defender, but I don't know if on behalf of Mr. Post.
Your Honor, I understand from the deputies that my client did not want to be present today.
Yeah,
So
he does that occasionally.
when I spoke to him, he was looking forward to being present. So I guess I would just leave it to the board's discretion.
All right, this is case number 24 CR.
Okay, this is Lakificent's Lair's fault. It's a fun hearing. I know it's not new. I know I'm late to the party with a lot of this stuff, but this is really cool. We've got a guy in here, so he's absolutely right about everything because he's a man and he has testosterone and he can't be questioned. Ooh! No, he's a complete moron. And the judge tells him to his face repeatedly, and it's hilarious.
137, State of Ohio versus Brian Keith Taylor. Are you Brian Keith Taylor appearing there from the jail?
Yes, sir. Yes, Your Honor.
All right. Just a minute. Wait, be quiet. This is case number 24 CR 137, State of Ohio versus Brian Keith Taylor. This is a pretrial being conducted by Zoom. The defendant's been indicted on 3 counts of aggravated trafficking and 3 counts of aggravated possession of methamphetamine. Mr. Taylor's attorney is Dennis Kirk, appearing from his office, appearing from the prosecutor's office, Prosecutor Collins. This is a final pretrial. I believe we have a trial date set for April the 7th. Now, I believe that discovery was filed. There's no, Mr. Kirk, did you file a compliance with discovery?
I did, Your Honor.
Okay. Well, we pulled these files last week, so we, actually I see over here there's a red jacket. I see them. Yeah, okay. And then it looks like the state filed an additional discovery this morning with a lab report on it. And you received that?
I did receive that. Yes, my client's not yet aware of it, but I will take that out to him.
All right. And I don't see any pretrial motions filed, or did you file any?
I did not. I did not see the warrant for any, so I did not file any.
All right. Now, what's the status of the case then in terms, I know we have a trial set on the April 7th, so that's actually inside the 14-day window, but I believe that this was the best we could do on the scheduling date. So what's the situation here with this case, counsel?
It's protected.
This guy is terrifically stupid. He's so stupid, it's fun.
I have made my client aware of his plea offer. We did actually negotiate on that. I have made him aware of the 14-day rule. Also, the form to basically I forget what the technical term for it is, but basically the plea refusal form, gone over that with him as well. He does not wish to sign that form, but has not necessarily stated he wants a jury trial either. He did want me to go back to the state with some additional things, which I did, and they declined to change the offer. So at this point in time, I'm not sure what he wants to do. He's never given me a clear answer.
So, Mr. Taylor, is it, are you rejecting the plea offer the state made and electing to go to trial? Is that your decision?
The process here, this pre-trial hearing, I mean, I got motions I'd like to file.
Well, you're not representing yourself. You have an attorney. And so,
I know that.
Well, wait a minute. Just wait a minute. I'm going to address this. And under the
I got motions I'd like to file. Yeah, you can't. You got an attorney. That's against the rules.
rule, motions, if you have an attorney, only your attorney can file a motion. So if you prepare something that you want to file, I have ordered our clerk's office not to accept those. They will not accept them because you are not representing yourself. The only way you can file a motion is if you represent yourself, in which case that would be a huge mistake, and you haven't asked for that, and there's you be quiet, don't interrupt me when I'm speaking. I'll give you the chance to talk. You just be patient, listen, okay? One of your problems may be that you want to speak instead of listen, and that's a big mistake too. So, getting back to my point is that there's not what's called a hybrid representation system in Ohio in a criminal case. The defendants can't file their own motions. Now, your attorney's indicated that he had reviewed with you and didn't find anything that had any legal merit, arguable merit that he could file. And under the rules of law, attorneys aren't permitted to file frivolous motions just because their clients think they should. They're the attorneys. They're the ones that know the law. They're the ones that know the rules of professional conduct. They're the ones that are bound by it, not a defendant who wants to file any kind of number of motions based probably on what you've seen on TV or in the movies, which is, again, a real big mistake to believe that kind of crap.
In short, you're dumb. Your attorney's smart. I have zero faith that you are thinking of anything that the attorney didn't. Shut up.
So that's where we're at. Now, going back to my question, are you rejecting the plea offer?
Yep.
Yes? Okay, then we will have a trial on April the 7th. All right, so does the state expect this to take more than 1 day?
No, the state expects this to be finished in 1 day.
Okay. And you agree with that, Mr. Kirk?
I would agree with that, and I would note just for the record, I've been given no names, addresses, phone numbers of any witnesses, so I don't think we'll have very many, if no witnesses at all.
Well, if there's going to be any witnesses, Mr. Taylor, you have to give those to your attorney so that he can file and upon those were due by today, so if you've got them, get them to him right away so he can give them to the state. I'll give you till tomorrow to do that. Now, anything else that we need to discuss in this case?
Yeah, I want to ask to have my attorney removed. I got grounds here. I asked him to file a few motions which are legitimate. I mean, this ain't from
I've got grounds here. It's also just the pattern of speech. It just sounds so stupid. I mean, it is stupid in substance, but he adds a nice theatrical flair to it, too.
This is from going through the law book and studying day in and day out. Everything I've got is, I got the case numbers, case laws, I got...
Motion, what kind of motions are you talking about?
Case laws. Of course you do, Pumpkin.
About Mr. Taylor?
But one is a motion to suppress. One is, and I got one here, it's a motion...
Motion to suppress, but this is I believe this is a undercover buy situation, isn't it?
It is 3 buys.
Okay, so I don't know what kind of motion to suppress would be appropriate. What do you think could be suppressed?
Yeah, you sold drugs to undercover cops 3 times. They have it on video. But you've got grounds. Okay, good luck.
It'd be...
Well, if you know so much about the law, you should be able to answer that question. I've got an attorney here who knows the law and tells me there's no basis. And now I've got you telling me there is, and I ask you what it is, and you can't tell me.
I asked you to file this motion, and...
I know that. I'm saying is, what is it you think should be suppressed and why? What's the legal basis for it that you, being a non-lawyer, has come up with that an accomplished lawyer has not?
That's on my paperwork here.
I like how the judge he's incredulous from the start and he doesn't hide it. Not for 1 second. Please do tell me the grand theory you've come up with that the smart guy that I know who practices in front of me could not conceive of himself after years of law school and practice.
Here at the same time.
So you have an answer. What is it you would seek to suppress? Pardon me?
I don't know.
You don't know? Okay. Anything else you want to bring up?
I'd like to.
I have a motion to suppress, but I cannot say to you what I would like to suppress. Okay.
Have my attorney move from the case and have another one, please.
Wait a minute, I'm having trouble understanding you. I can hear you.
I like to remove my attorney and get another one.
Okay, well, you have until April 7th to get yourself a new attorney. If you want to get a new attorney, you can do that. You'll have to hire them because you didn't hire Mr. Kirk. You didn't have the money to hire an attorney, so I appointed him for you. So, he's your attorney unless you get a new attorney. But if you do, they need to be ready to go to trial on April the 7th.
I can't get another court-appointed attorney. I can't afford an attorney.
No, you have a court-appointed attorney. I've given you a court-appointed attorney.
But he's not representing me.
Yeah, he is. He's representing you, and he's had conversations with you and discussions. You don't like what he's telling you. I get that. If I were in your position, unless they were telling me you're going to walk free and the state's going to give you a written apology and $1 million, I wouldn't be happy either. But, he's not going to do that. So, unless you can tell me why he is not, he shouldn't be your attorney, and you've given me no reason other than the fact that you don't like what he's saying and he won't file motions that aren't proper, which is no attorney would file. So getting you a new attorney would not mean anything, because a new attorney wouldn't be able to file frivolous motions either. And if I gave you any attorney who knows what they're doing, they're not going to do anything different than Mr. Kirk is. Mr. Kirk's been doing this a long time. Now, anything else you want to bring up?
I don't know this attorney, but from what I've seen in this hearing, he's well dressed, well spoken, and knows what the hell he's talking about. I mean, I've only seen a couple minutes, but I like his odds with the attorney a lot better.
Yes, I have grounds, man. I haven't.
I asked you what your grounds were, and you didn't tell me anything. You said you didn't know on suppression.
I'm trying to be respectful. Wait till you're done talking.
I'm sorry, what?
I'm trying to be respectful, man. Wait till you're done talking. You got only once for interrupting.
Okay. I asked you to answer my question, and you didn't when I asked you what your grounds were. Now, I'm not going to give you another attorney. If you want to get a new attorney, that's up to you. You feel free to do that. You'll have to hire that attorney. But I don't know who told you that you're entitled to get more than one attorney, because the court has appointed you an attorney. Mr. Kirk is qualified and competent and experienced and knows way more than you'll ever know about the law. So just because you've been in court a few times doesn't mean you know anything about the law. Just because you got a book you can read doesn't mean you know anything about the law. I could read a book on brain surgery, but that wouldn't make me a brain surgeon. You can read a book on the law, and it doesn't make you a lawyer. Now, any other things you want to bring up, Mr. Taylor?
Myself?
Well, that would be the biggest mistake you've ever made in your entire life. Based upon what you've been telling me, I don't think there's any way in the world you could represent yourself. Pardon me?
I haven't been able to tell you nothing.
I can't understand. You're mumbling.
I haven't been able to tell you anything.
Well, you're not the attorney. You're on trial. You don't get to participate in your defense, because that's what an attorney is for. That's why you have one.
But am I allowed to have a fair and just defense?
Oh, absolutely, and that's what you're going to get. We'll have a fair trial. We'll have a jury, and we'll have a trial.
I don't have all my discovery. I'm missing 12 things that I'm undiscovered. I'm begging for.
Well, he's got the discovery. Let me explain here, Mr. Taylor. I met with your attorney and the prosecutors before this hearing, and he kind of outlined to me some of the things you're talking about. As I understand it, you have everything of any importance. I think he said you had mentioned that you didn't have a copy of the resume of the BCI analyst or something, which is minor. It doesn't mean much. He can get that to you. He will get that to you. But the other things that you want, my understanding, he's given you more than what most defendants get in these kind of cases, because usually there's a counsel-only discovery restriction. But since the identity of the CI is known, apparently they have let you watch the videos, right? You've watched the videos of what they say are the buys, right? And you've gotten copies of everything that he has, pretty much. Is that correct, Mr. Kirk?
That is correct, yes.
All right, so I don't know what you're talking about when you say you don't have discovery, because you've got everything that he's got. And that's it. Discovery is what he's giving you what he has.
My discoveries don't even have counsel eyes only stamped on them.
It doesn't have to have a stamp on it. It's done by email.
And at the same time, I get a piece 1 week, I get a piece 2 weeks later, and I get a piece Monday.
All right. Well, good. It gives you something to do. So what? We still got 10 or 12 days to try. But again, you're not going to be the one that's going to be questioning the witnesses and presenting evidence and making arguments. That's what your attorney does. Pardon me?
I'm afraid of it.
I would be afraid too if I were on trial, but that's not why we're here. This is a final pretrial, and we're ready to go to trial. The court, we're going to send out our jury notices today. State's ready to go, and you're going to be ready to go unless you get a new attorney. And again, you're not going to get maybe you can find somebody to be willing to take the case and go to trial on the 7th. But that's going to be on you. If you want another attorney, you can get one. But all this stuff you're telling me doesn't amount to a hill of beans, as my dad would say.
I represent myself.
Pardon me?
I represent myself.
Well, if you want to do that, how are you going to do that? What do you know about the law?
I don't know that much about the law.
And so you want to go to trial not knowing much about the law against a prosecutor that does know the law?
I think my percentages would be higher, yes.
Pardon me?
I think I would have, my percentages would be higher, yes.
Well, I can't understand what he's saying.
Yeah.
He said his percentage would be higher. His percentage of winning would be higher if he...
Oh, yeah? What do you think that would be?
I don't know.
Well, give me the odds, and I'll take that bet. Because you're absolutely 100% wrong. Everything you're saying here is exposing the stupidity of your position. And for me to allow you to represent yourself would be guaranteeing you a conviction. You'd be convicted of everything. You don't know what you're talking about. Have you ever picked, do you know what the word voir dire means? Okay. Do you know what the separation of witnesses is?
That's one of my motion for seven.
Well, we don't get separation of witnesses, I ask you.
Yes, yes.
Okay. So what is it? Huh?
Motion I asked him to file.
Okay, well, that is filed at the time of the trial. When we start the trial, that's an oral motion. What kind of a motion did you want him to file?
You have to give me time to get it.
No, you're the one that claims to know more than he does. You should have been prepared to tell me. If you've got all these arguments, don't tell me you got to sit there and try to figure this out, because we're not going to sit here all afternoon. You tell me what it is you wanted him to file. You just told me you wanted him to file something. Tell me what it is you wanted him to file. Don't tell me you got to go look for it.
I'm pretty organized here.
Well, why can't you answer the question then?
Because I can't tell you without.
Okay, well, look at it. You should be able to find it. I'll give you 15 seconds. Find it.
File a motion for the rest of my discovery.
There is no other discovery to file, to get. You cannot. Pardon me?
I got a list here.
What?
I think he's basing his list off of other people in the jail, because he thinks there's a set number. Sir, he thinks
Be quiet. Let me hear what Mr. Kirk's saying. Go ahead.
He thinks there's a set number of discovery items. I've told him that is a myth. Some people may have 14. Some people may have 2. And I've explained that to him. However, he does not trust my advice on that. I do not believe he's missing anything other than there is a lab report that was just filed that I will be taking out to him. But he thinks there's some sort of mythical set number of items.
Okay.
Judge, I can probably shed some light on this as well.
Go ahead. I would like to.
Some defendants believe that they should have copies of the buy money, for example. In this particular defendant's case, those are actually pictures that were on the digital evidence that he would not have access to out there because he's in jail.
Right, I understand.
There are several things that are digital evidence that he physically cannot have access to because he's in jail.
Okay. Well, your attorney has those, and he's shown them to you, as I understand it, right?
Yes, he showed me the digital stuff, but he has showed me, yes, right. But also, if they're going to have PCI experts on the stand, and we get a chance to cross-examine them, shouldn't I have their qualifications and all that for cross-examination? Also,
cross-examination would be based upon their report.
Also, the submission report to the BCI lab, I don't have, and I don't have the physical evidence or the witness. I got the witness list. I don't have the CI's felony report. I don't have the forfeitures. I don't have disclosure of all evidence and everything from them.
Well, your attorney has it, and he has it, and he's discussed it with you. You don't have to have all that with you in jail. I don't know that you'd have room for it. So,
That doesn't exist.
Pardon me?
A lot of this that he's talking, so he just said he doesn't have a list of the forfeitures. There are no forfeitures in this case.
Oh,
He
well,
has
there would
the
be, yeah.
CI's, he has the CI's criminal history. He just doesn't know how to read the discovery. We provide the CI's.
Okay. So-
ECA from- He doesn't understand what he's reading.
Right? Correct? This right here is a signed paper that's in my particulars. That right there, if my daughter needed a permission slip to go to school, I can put this on it. Nothing there says that goes to a bill of particulars. There's no date, no stamp, no nothing on my bill of particulars.
All right, well, I don't really, it doesn't matter. It's immaterial. You have copies of what is filed, and that's what's important.
I can answer this too.
Legal process.
All right, wait a minute.
I can answer this too. We don't file a bill of particulars in court because it names so much protected information.
Right.
We file a notice of filing. The bill of particulars doesn't get stamped or anything like that. It's secret.
I understand, but it still has to have some type, some look, because they can be reproduced. Everything I got can be.
Okay, well, again, you're operating from a complete ignorance of what's going on here. As she indicated, the bill of particulars does not have to be filed with a file stamp in the public file. And in fact,
should go with complete ignorance.
Oftentimes it's not, because it names people that are to be remain confidential. And in some cases, we've had a situation where the paper picks it up and prints it all before the trial, and then that person had all that information out there that could potentially prejudice the defendant. And so your complaint about it not being file stamped, it means nothing. That is a big fat zero that means nothing. You have a copy of it, and that's all you need.
Criminal Rule 16C says that it has to be prominently stamped, counsel eyes only. And everything they gave me.
Well, it's not stamped counsel eyes only. You've got everything in this case. Now, I'm not going to argue with you anymore. All right? The bottom line is, what you're saying is all without any legal merit whatsoever, because you've read a book and you think these things say this and that, and they don't. And you're not entitled to stuff that doesn't exist. You don't have to have stuff that doesn't have to be file stamped, and nothing that you've told me means has any legal significance at all. It seems to me that what you ought to be doing is focus on the allegations in this case and the evidence that you do have in this case, which is apparently some videos or audios and witness statements and people who are going to testify. That's the stuff you need to be focusing on, not on a whole bunch of stuff that you think you should get that you're not, that either one doesn't exist or two is you have it and you don't understand it, and that's your fault. And that's just, again, the fact that you don't know what you're talking about. That means
I charged for everything.
Pardon me?
I brought so much to my lawyer, and he has dismissed and excused that. I got this form smoking crack in the video, but he dismisses it and justifies it. It says I'm smoking a pipe, and nowhere in it I'm smoking a pipe, but he dismisses it and justifies it.
Well, it'll be in the trial. I mean, if whatever the videos show, they show. I don't know what's on there. This isn't about that. We're not going to argue about that. Whatever the evidence shows will be what is going to be introduced at trial if we're going to have a trial. And it sounds like that's what you want. So if you want to have a trial, that is completely fine. We're going to go ahead and send out a jury notice here this afternoon, and we'll summons in the jurors, and we will see you on April the 7th. Again, if you want to represent yourself, again, I would tell you that would be a big mistake. But if you want to file that motion, I will have a hearing on it and give you the opportunity. But I can tell you that you will absolutely have no chance in the world at a trial based upon your performance here today. Because just because you represent yourself doesn't mean you get to bring up everything that your attorney said you can't. Because if he says you can't,
give us a straight assessment, Judge. Don't hold back on our feelings.
Can't do it, and he's right, which I'm guessing that he is, because he's been around the block a few times and tried cases in this court. then you're not going to be able to bring it up. And so when you're being upset with him not bringing up stuff you want him to, when he tells you you can't, it's not admissible, that's going to be the ruling of the court. And, most likely what will happen is, you're going to come in here thinking you can do this and that, and you can't, and I won't let you. You'll end up hardly having anything to say on your own behalf. You're not the first person I've dealt with that's represented themselves, or wants to represent themselves. And, if you want to do that, you can file a motion. There's a hearing I'll have to go through and ask you a whole bunch of questions that will point out, what a big mistake that is. You'll still have to have a legal advisor to stand by to answer questions for you at the trial. They won't be able to participate, and we won't start the trial, you representing yourself and then deciding, coming to your senses and finally realizing you've made a big mistake and then say, okay, Mr. Kirk, I'm in over my head, take over. That's not the way it works. Once you start it, you're going to finish it. And so, again, under the law, unfortunately, the court is not permitted to protect the biggest right that a defendant ought to have, which is the right not to be stupid. And unfortunately, you do have the right to be stupid, and you can exercise that at any time. And if you exercise that by representing yourself, that will be the biggest mistake you've ever made. I'm just telling you that. I can tell right now that you're not going to be able to effectively represent yourself. But if you want to, once we go, just be quiet, I'm explaining. If you want to file that motion, that's one motion I'll...
Quiet now. Quiet now. I'm carefully explaining to you, to your face, exactly how stupid you are. And I'm absolutely on a roll, and I'm correct.
Permit you to file on your own. We'll have a hearing on that, and we'll go through all those requirements I'm going to have to do. I'm done with you now because I've got other cases I need to move on to. This is a pre-trial, not a trial, and I'll make that ruling. And so if you want to do that, I'll have a hearing on that, maybe Monday, and that'll give, and we'll see what's going to happen. Again, I'm telling you, do not try to represent yourself. And because, when you...
I think this is in Ohio, although this guy's got a little southern drawl. Just a little. But it comes out at times. When he really gets rolling, it comes out.
You said your odds will be better. They'll be infinitesimally worse. They'll be so much, so bad that you can't even imagine it. And again, these cases, in cases like this where, you need to focus on what the evidence is as opposed to what you think the attorney is or isn't doing. That's the issue. Look at the evidence that you do have. What is the evidence against you that the state says they're going to present? And then make your decision based upon that. And as far as asking for stuff that's not out there, or stuff that you can't have.
Okay, where's Highland County? Was it south? It's down by like Cincinnati or something? Because this guy sounds like he's pretty close to Kentucky. By West Virginia? All right, I could buy that too.
In jail because it's digital, and your attorney has shown you those things. You have everything that the state has. There's nothing more they can give you. And so, you could file 135,000 motions asking for more discovery. And if there's nothing more to give you, they're not going to be granted, So, what you're asking for is stuff that you apparently think you know about that you don't. And again, I don't know where you come up with these 14 items of discovery, but to the extent that you're getting advice from people that are in jail, think about, how smart they are if they're where you are.
Every idea I'm getting is coming from the Criminal Handbook 2018, and everything comes out of it that I've got.
You've got everything you're supposed to get. That means the criminal law book doesn't create things. It just tells you what you're entitled to. The state has provided all that. Your attorney has got it. He has shown you everything other than this last lab report, which just came in, and he's going to give that to you. He just got it today. So, you have it. There's nothing that you are entitled to have or can have that you don't have. So, I don't know. I don't know what else to say. So, all right. Now, we're done. Anything else from counsel?
No, Your Honor.
All right.
No, Your Honor.
All right. Thank you.
Oh, that was fun. That was just pure fun.
I will be out to see you, yes.
Thank you, Gibson.
Okay, Briscoe.
Oh, I forgot about this. I got a little Judge Mom. Don't worry, the Hot Mess Express continues. This is this is ugly. There are two appearances that are bad, but the other appearances were just as bad. In fact, one I cut out one in the middle. A guy had a colostomy bag. I mean, it goes without saying it was a shit show. But these two appearances are pretty good. Watch Judge Mom try to hold this together.
Do I have Briscoe here? We're gonna. That's what we need to see by themselves. Okay. Casares. Casares, come on up.
Statement for a while. Yes, ma'am.
Ms. Casares, I show you have a citation for operating an unregistered motor vehicle, failure to appear as a parent, animals at large, rabies vaccination tag.
Say something.
Sorry?
I have not driven. The car tickets are not my tickets. Those are tickets that my sister got under my name that I can probably, if they roll the camera, will prove that it's not
It's
me.
one ticket. It's operating an unregistered motor vehicle.
The car since 2017, ma'am.
You what?
Owned a car since 2017 or driven one. I have a license, but I don't use a car.
What's your sister's name?
Her name is Bobby Casares, and she always uses my ticket. When she uses my name, it's under Linda Casares. She doesn't ever say Linda Medrano. She always puts Linda Casares because that's my maiden name.
What's her date of birth?
7/31/77. Mine is 6/10/77, but she looks identical to me almost.
Okay, on that one, I'll enter a plea of not guilty for you. I'll give you let me finish. I'll give you a $500 PR bond.
Thank you.
And Karen, if you'll send that to Candy.
And the dog tickets are...
Give me a second. Okay, I'm driving the bus, okay? Let me drive the bus because I got to write all this paperwork.
Okay.
Get all ahead of me, okay? I promise you're going to get an opportunity to talk.
Let Judge Mom drive the bus, damn it.
Promise. You say you haven't owned a vehicle since 2017?
2016 was the last vehicle I owned.
When was the last time you drove?
I have not driven a car since then.
Why is that?
Because I don't own one and I ride a bike. My car died. And when it was a flood a long time ago, my car died. I never got one back because I don't work.
You ride a bicycle?
Yes, ma'am. I got run over twice on a bike. I've never gotten a ticket though. I've never gotten a ticket.
Did you say you've been run over twice on a bicycle?
By a semi and a lady in a car ran me over.
And you're here.
She's been run over twice on a bicycle, but she sticks with it. just everything in this call.
Here to talk about it. What do you mean you got run over by a semi?
It ran me up and like hit me. The whole bed of the trailer hit my head and just like switched me by.
Do you ever take the city bus?
No.
Why not?
It takes too long and it's so
What do you mean you got run over by a semi? It's just all day long she's got this crap.
confusing now. It takes too much to stop and I can't afford that.
When was the last time you looked at the city bus system? I think they've done some streamlining.
Still costs $1 every stop. Or you have to buy a $2 pass, and I don't ever have tickets to go here and there. So I just ride the bus on the bike lane. But when I got run over the first time, I was on a curb. I got hit then the truck didn't stop. And then the lady that ran me over, I was parked at the stop sign and she just ran me over. She didn't see me. She just ran on top of me.
Wow, I'm so sorry.
Don't worry, it ends in tears.
Okay, tell me about these animal tickets for baby K.
Animal tickets, those are my daughter's tickets that when they would stay there, because it's my address, the ticket, they'd be out, the ticket would just get mailed to my house and they'd be sent to me.
Immediately.
Because it's my house. They're my tickets, but they're my adult daughter's tickets. They're her dogs.
But they're at your house?
They're at my house. They're not there. We got rid of all of them. Except for one. And it was a little brown mangy. But the other ones were pit bulls. They were all my daughter's dogs. But they don't live here. I got rid of all pit bull dogs. That's why they were those, but because it's my house, they give me the ticket.
Yeah, because
Yeah, the guy sitting in the orange, I cut that appearance out, but the guy sitting in the orange behind her is the one with the colostomy bag, and it was funny. It was funny, but it was too gross.
the definition of owner is pretty broad in the city ordinances.
It's in my, even though they're not mine, they're my daughters, they're still mine because it's my house.
Yeah. So how do you want to handle these? You can plead not guilty, set these for trial, plead guilty or no contest.
No contest and maybe set up payment arrangements. My daughter will have to pay for them, of course.
I'll time serve you if you plead no contest.
That'll work.
So are you pleading no contest to all three? Yeah. Next time your daughter wants to come stay with you with her dog, I guess the answer should be no.
Austin, thank God.
Yeah, go somewhere else. Or make sure the dog, is properly secured and has the tag and all that stuff. Okay, I'm going to time serve you on those. Now, you have from 2017 a failure to appear ticket because you didn't come to court, didn't bring a kid to court.
What kid? I don't know.
I don't know. Let me look and see. Let me see which kid it is.
don't.
Hold on.
I have 6 is why I'm asking.
No, it's a legitimate question. I need to pull it up. Let me look at the file.
Yeah.
Not your
I
first
like
animal tickets either.
I like Judge Mom talking up the public bus system. It's so her. She's like, she tells her I got run over on my bike twice. She's like, have you ever considered the bus?
Bryn, can you tell by looking? Do you have a way to tie into which? Oh, Adrian.
Son.
Do you have a child named Adrian?
It's the Tutunga's son.
Yeah.
He's in jail now.
Well,
he's under my mom's custody.
Well, of course he is.
That's not my kid. I've never had custody of him.
He's not
Adrian
proud of this.
Ulloa
He's in jail.
Garcia.
Under control.
Is that his name? That's my nephew. Not
no,
my son.
Adrian Sebastian.
Yeah, his middle name is Adrian Sebastian Ulloa is his name.
You're saying that's not your child?
My child. I've never had custody of him. My mother did. He's in prison now. His mom is named Bobby Ann Caceres. My son is Ezekiel Joe Garcia, Malachi Garcia, and James Foster.
Oh my gosh.
I told you the hot mess express continued, and I delivered.
Okay, hold on. Well, he came to court with you.
What with me? I never brought him to court. I don't remember bringing him. He was living with my mother. I don't remember bringing him to court. Honestly, I don't. Honor, I have bipolar. I don't remember. Honestly, I don't. But I've never had him under my custody. My mom's always had that kid.
Mm-hmm. Well, you brought him to court in 2017.
Remember,
and then he didn't come back. You and it says appeared with the.
Yeah, I've been trying to pull this my whole life. I've been trying to blame my evil twin Naughty Mike for anything that I don't want to be responsible for, and it's never worked.
Aunt Linda Madrano.
Yeah.
And I've got your ID here and everything.
I don't remember that. It's been like he got in trouble after that and went to live with my mom, and he's in prison now, going to prison for
life. But you never brought him back, and so that's why you got that ticket.
That was probably I didn't bring him back because he was no longer with me.
I don't know, ma'am. You were still we have parents that if they don't have the kid, they still come back because you were ordered. You can argue with me all you want, but you were ordered to bring the child. And so when you couldn't bring the child because he was gone, all you had to do was come back and say, I don't have this child anymore.
I apologize. I really don't remember so much. Since then, a lot has happened and I don't remember.
Yeah. So you can plead not guilty to that, set a bond, come in and talk to the prosecutor.
Okay.
Do you want to do that?
What? Guilty? I know I'm guilty because it's me, but I don't remember. So yeah, or no context. I don't know. I'm not in my right mind right now.
Just tell me what you want to do. You can plead not, if you're not in your right mind, then let's plead not guilty.
Not guilty.
So you can come in, talk to the prosecutor, see if you can work something out.
Yeah.
When you go, I'm not in my right mind, well, that tells me that I probably don't need to be accepting a plea from you.
I'm not right now, so I'm not guilty.
Why has this become, what's happened in the last 2 minutes that's made this difficult?
2 minutes, everything in my head that's happened since I got arrested. Right before I got arrested, I found out my husband was having an affair, and I went to jail. Caught the doctor, it's getting beat up. So my head is not right now. I had a TCP appointment today that I didn't go to, but I've been waiting for 2 weeks.
When was your TPC appointment?
This morning at 11.
Okay.
How do they do this all day? How? I literally could not last a day. I couldn't.
Well, there's usually a TPC person there at the jail.
They told me, I got here last night. There was nobody here. They told me that I would get a ring today and I'd probably go home. I don't know.
Saldivar, is there somebody there from TPC?
I can check if there is, Judge.
Thank you. Because they should have somebody there. We try to keep a TPC counselor there at the jail so that they can at least help communicate for you, but you're going to get out. You're going to post what's called PR bonds. You don't pay anything up front, but you need to show up here. Okay. So no excuse for not being here. You have to be here by 2:00 tomorrow, which means you need to be here about 1:30. He's going to give you the directions on how to get here. The animal tickets are gone. We're going to see if we can find out anything on the other ticket, the one that you think it was your sister, and then on this one with the failure to appear, where you didn't come to court with the child. You came the first time and then you didn't come back. You can talk to the prosecutor, see if you can work something out on that, or explain to them, hey, I was just showing up. He's not my kid. I think that's a great thing to say. But the problem is you came that first time with that promise to appear to come back. So anyway, I think you've got some things that you definitely could talk to the prosecutor about, okay? Okay, so let's just take a breath, get out, and we'll see you tomorrow, and maybe we can get it all straightened out, okay?
Thank you.
Thank you.
Okay, let's skip. This guy's kind of fun. It's not very long, but it's fun.
Hi, are you Mr. Briscoe? Are you Mr. Briscoe?
Yes, ma'am.
Okay, take a step forward. I need you closer to the microphone. Thank you. How are you feeling?
Anxious and nervous.
Okay, well, don't be nervous. It's just you and me. Do you know where you are?
Yeah, jail.
Okay, when you talk to me, look at me because the microphone's not picking you up when you're doing that, okay?
I'm sorry, I'm nervous.
That's okay. Don't be nervous. It's just you and me, okay? So you're in jail because...
I mean, I think that's why I like Judge Mom. She honestly is sweet. She really is. She can get cranky with them, but you got to earn it. And that's really where her heart is.
The police said that you were intoxicated in public.
I wasn't drunk. I was drinking alcohol. I drank, like I had a shot, a fireball, but I mostly was like smoking like methamphetamine.
You can be intoxicated on drugs too. So yeah. Okay. So that's a Class C.
I wasn't drunk. I just had a shot and I was on drugs. He had time to think what he was going to say to the judge, and that's what he came up with.
Misdemeanor punishable by fine of $1 to $500. You have the right to hire a lawyer. I cannot appoint you a lawyer. If you want to hire a lawyer, you would plead not guilty, and we would let you out of jail. And do you still live in Dumas?
Yes, ma'am.
Okay.
But I was planning on just leaving and going back home where my family is.
Where's your family?
Sherman, Texas. That's where I'm originally from.
Sure.
In Texas.
What were you working in Dumas or up there at one of the plants?
I came to Dumas for rehab. I came to Dumas and then I ended up falling back into the same habits.
Okay.
And that incident happened last night. But like it wasn't like made up story or anything like that. Like I legit was coming from I had met a new girl yesterday. Her name is Bree, this light skinned girl, whatever. And like we went to Goodwill, she ended up robbing that place, and she didn't tell me that she was gonna do that. Well, not rob, but like she stole a bunch of clothes, and she didn't tell me or the guy that picked us up from the store, whatever. And then so after that, he offered to.
See, what had happened was, Judge, I wasn't drunk. I did a shot and some drugs, and then we were on a crime spree, stealing stuff. Oh, okay.
He offered to smoke us out, and so we went past his buddy's house.
Okay, you're gonna have to help me. I'm pretty nerdy. What does smoke us out mean?
Oh, he has to be wanting to smoke. Like,
okay,
that's what that means. For free on him. You know what I mean? On him, meaning like he was gonna pay for it and all that.
That I understood. Okay.
Mm-hmm. And we ended up at his cousin's house. He said it was on some street over back where by where they picked me up. The police did last night, or early this morning, whatever time it was. And like I was literally like fearful for my life because I ended up going to the one of the hotels that was right there by the Quick Trip. That was right there, and I just this random white guy who had just got into town and had his room had offered to let me stay there, but I noticed that there was this car following me.
Wait, you went to this hotel or motel, whatever it is,
and that there was a guy outside unpacking.
He offered to let you stay in his room?
I actually asked him for a ride down the street, like to the police station, and he said that he was that tired.
You did not want to ride to the police station. Tell me. Why would you? No, I never ask anybody for a ride to the police station. Why do you?
All right. First of all, she's like, all right. Explain this depravity to me. And now she's like, forget it. I don't need to know. You're here on like a small charge, and we've got like, you're talking about felonies left and right. But I guess the next part of his story is he claims he wanted a ride to the police station. Mm-hmm.
You want to go to the police station?
Because I was literally scared. Like I'm still scared. Because when we were in the car, right? How I ended up like getting away from her and him because we were smoking, but like they were up. He made me get out of the front seat and get in the back seat, Mary in the front seat. But the whole time they were like messing with something, but like it was super dark in the car, and they both were being like real quiet about it. And like I kept like trying to move the seat, but then like he would just keep doing it. It's like I don't know if he had a gun or what it was, but then like I got out of the car because I was like I just need to smoke a cigarette, so I tried to just play it off. And then he got out of the car and she came and she's like, Grandma, she's like, where are you going? Like, you're okay, you're good, you're freaking out. So I'm not freaking out. This just looks like I didn't say it out flat because I know that they know certain people and shit like that. So sorry about my language. They know certain people and I just didn't want to get in trouble or I didn't want to get like hurt or something like that. So I took off walking. I said that my friend was down the street. I had no clue what area we was in anyways. I just completely made that up to them so I can get away from them. But I ended up walking like by the hotel where I like originally saw the white gentleman, and like there was like a car that kept following, and right across the street there's like some, I don't know what that place is called, but it's a bunch of like Hispanic people working there. I don't know if it's like a fast food place right there or something, but it was late at night and they were all like getting off work, but this one car pulled back and somebody in black got out of the car with a dog. And then the Mustang, it was a white Mustang, and they pulled all the way over to the edge of the street across from where me and him was. And I was like smiling, like playing it off because I told my friend. So luckily I did find somebody that was there. So I knew I was high, but like, I know I wasn't making this up. Like I literally had to do that to get away from them.
All right. I mean, this is just good on so many levels, but just another rule to live by. You don't want to utter the phrase, I knew I was high during your appearance in court. If you can avoid that, that's better.
So I'm not making any of this up. And I kept seeing cars that started, it was a silver car with rims on it, kept following me. I kept like going over I was so scared.
So that's why you were trying to get to the police station.
Yes, and I was so scared that I kept going over like the very top of the the little divider between the hot freeways. I kept going over it, and the same cars would just hurry up and like fly back around. The same as that cars. and the police kept telling me that I was tweaking. And I was like, I've been high. I've never shot up. I don't shoot dope like that. I literally haven't smoked in almost 6 months. Like, I just smoked for the first time like a couple of days ago.
He's fixing to confess to the Kennedy assassination right now, and anything else that you can think of.
So, like, I know I'm fully aware and understand what's going on around me.
Yeah. No, the officer said that you were that you told him that you felt like you were being followed, and it was kind of like they brought you to jail kind of just for your own safety to get you out of that situation.
I begged him to arrest me. He did not.
So how are you going to get back to Sherman?
I'm going to clip that. First of all, he says, I begged him to arrest me, and her response is, "Oh." Judge mom, everyone. There you go.
Oh, I lost volume. I'm sorry. What did you say?
I don't know, but I'm gonna try because I can't go back to do this because I'm so scared. Like, I'm really scared.
So, like, when you get out of jail, they just like let you out of jail. So
leave me there after all that was going on last night. The police officer was just gonna leave me there. I was like, can you just at least drive me away from this area?
Do you have any family that you can call?
No, I don't. Well, I have my mother, but they're over there, and it's like 6, 8, 7 hours.
But can they get you a bus pass?
Most likely, but I feel like they probably would follow me. I don't know.
Were you in Sherman, or were you in Dumas at an actual rehab, or like just staying
at the refuge? And then I got
this stream brought to you by the public bus system, wherever Judge Mom is.
My own place.
Is this was this like a condition of probation or something?
No. I did on my own.
Well, I don't know what to tell you, Mr. Briscoe. I feel for you, but
because when we was in the car, the reason why I had to get away from her is because, like, me and him were telling her that she was wrong for what she did, for stealing all those clothes and stuff, and she was making a big scene there at the place or whatever, and like, I thought he was on my side, and then he made me get into the back seat, and before we went to that house to where we actually was smoking, he took us to his friend's house, and they had 2 big dogs, I think pit bulls, and they had a small one. I seen 3 different guys, 2 of them with the big one, and then when I'm right there in the traffic way, whatever, where the police saw me and we met up right there, there was that same guy was walking with the dog, with the little pit bull, and I remember those same 3 dogs from that house that we were just at.
That's crazy. Do you could you call somebody at the refuge and see if they can?
That's crazy. Oh, he's taking that as like she's going along with it, but no, she's just making a statement.
Help you?
Yeah, I probably can.
Well, I mean,
I don't even know how the car was out because, like, I took off down the street and around the corner, right? I don't even know how they could find me because I was like dipping and dodging through like the neighborhood trying to like, but like he has some kind of like device in his car where he can like scan or track like whatever. Because she made the comment, she was like, "You did bad." She's like, "You're not about this life." I said, "About what life?" She was like, "Well, now he just got to do what he got to do." And I was like, "What does that even mean?" And she didn't further explain or anything. So that's just, to me, that means that they were going to hurt me or something because they were moving sketchy together. And I had just met her and I thought we was cool, you know? And I was going to go home anyway. I didn't even want to hang out. They begged me to stay, like, hang out with them.
What do you want to do? What do you want to do on this charge, this public intox?
What do I want to do with it?
You can plead not guilty, but then you'll still have to come back here.
Guilty, I know.
Or you can plead guilty or no contest. You still have to come back either way, because if you plead guilty, I'm going to find you guilty. I'm going to assess a $484 fine and court cost. I'm going to give you a day jail credit. You're still going to owe $334.
Okay. Yes, ma'am, I can do that.
Or you can plead not guilty and set your case for trial.
I'm guilty. I'll plead guilty.
Yeah. I mean, he does plead guilty. I give him credit, but you can go ahead and plead not guilty and go to trial where you have admitted not only to what you were charged with, but about 50 other things under oath on video.
You want to plead guilty?
Yes, ma'am.
I'm sorry?
Yes, ma'am.
Okay. Here's what I'm going to do. I'm just going to make your whole fine and court cost be $150. And I'm going to release you and your time served. I need you to try to get to Sherman. So your goal now is just to go home. Okay? Okay. You're good to go.
Well, there you have it. That was just a lot of fun. That was a lot of fun. This happens sometimes. I did a stream earlier, which, by the way, was fantastic. Judge O'Donnell laying down the law. It was fun. Then I had all this stuff I had to do. I had actual law firm stuff to do. There was a Yesenia sighting, the whole deal. But I had a bunch of these clips that I was collecting or whatever. I come back, I'm like, all right, I'll do a stream, and I didn't know how to deal with it. So I've got a whole bunch of stuff, and it's all disjointed. None of it makes sense. Now I don't know what I'm gonna do for title and thumbnail. But as I'm putting it together, I'm like, that's why the current title is a big mess. Like, I can't even remember what I have in here. But then I start doing it, and I'm like, damn, this is really pretty good. It got even better. I didn't notice the thing that got, there's a lot, but what him saying that I begged the police officer to arrest me, and her saying, "Oh," that got me. It really did. So much good stuff. I mean, we kick it off with that wackadoodle, and I missed the boat, and I know everyone's done those, but it was still fun to do. Then we what else do we have? We had a good Karen. We had a good Karen, of course. We had a good Karen with the worst defense ever on a traffic ticket. Then we had Shaquille O'Neal not showing up. Then we had that guy who wants to represent himself, just getting a straight story from a judge in Ohio. That was a ton of fun. It was all fun. It was all fun. All right. Thank you all for coming out. Good times. I'll figure out something for a title and thumbnail. I don't know what it is yet, but I'll figure it out. I'll see you all soon.